Very warm good evening to all. Today we proceed with a topic which is actually of a very social concern, because suddenly when a person disappears, the whole family and his relatives are like what to do next. Firstly, it is like a very deep impact on the family itself, that they find it very difficult to survive. There are so many issues. There may be properties, there may be LIC policies, there may be so many things which has to be decided. Suddenly, when a person disappears, it is a very, I would say, an impediment in the life of the people who are left behind. As we have seen in COVID situation, there were some people who did not even know that their husband or their counter or any family members have taken out LIC policy also. Now today's topic actually deals with this. Now in COVID situation, actually we had the certificates that a person is physically dead. But when we refer to section 107 and 108 of Indian Evidence Act, we find that there is no physical death. Here the person's death is not known. It is not in front of the uh, or the society or the country or the people or in front of the world. It is a fictional death which we the people will not know. In the eyes of law, you are dead. It tantamounts to become a not a physical death, but in the eyes of law, you are dead. Now, how do we prove? It is actually really very difficult to prove. But the Indian Evidence Act has a very good got provision for the same. Now, under section 107 and 108, you have to conjointly read both these sections. If you read 107, you will find the years as 30 years. Now, when you say 30 years, understand. See, 30 years such a long period. But 30 years period is said under section 107 of Indian Evidence Act for the, it is presumed for the continuation of life. The life is presumed to be continued. But when we come to section 108 of Indian Evidence Act, the life, it is like the presumption that the person is no more, person is dead. So there is a difference between section 107 and 108. But normally we refer to section 108 because it is a short period and it is assumed as to be dead. Now when we say it is dead, it means that there is no person. Just a minute, I will mute somebody. Kindly mute yourself. It is getting disturbed. Sorry. Now, when we say section 107 and section 108, 108, these both section, if you read conjointly, you will find there is a vast difference between them. Section 108 is actually an exception to section 107. 107 holds the presumption for continuation of life, and section 108 of Indian Evidence Act says that the maybe the person is no more, and it is an exception, it's a provisor to section 107. Now it is actually very easy to understand that a person who has not been heard for the last 7 years, naturally who would have heard is the near family members. It is wife, the neighbors, the relatives, or the person. If he has been working, then the people who are at his workplace, they may know. Suppose a person is in army, and from army if he disappears or missing, I have heard from a army person कि आर्मी में मिसिंग का मतलब क्या होता है. आर्मी में मिसिंग का मतलब होता है डेड. ही इज नो मोर. ऑलवेज रिमेंबर दैट. Now, see, the missing complaint has to be lodged here. Now, you take the word missing from here. If you lodge a missing complaint on the day person is no, like he disappears suddenly in few days, you know that in spite of your genuine efforts, that person is not traceable. Then you have to lodge a complaint. But now the person is no more, and for 7 years you have to wait. Now there are a few judgments of the Supreme Court as well as the High Court which says there is a procedure to be followed. You cannot simply go as a wife or as a son, as a daughter, that my father or my mother is not available and she is presumed to be dead. So my death LIC policy, it has to be favored in my, and my I have to be given compensation or the proceeds of the LIC policy. There may be a property in that person's name who has disappeared. Now disappeared means he is no more for the last, he is not available or not in connection, not in connect with the person mostly he will be in connection with his wife and the children. Now, even if he's working in army or if he is working in Naxalite area, away maybe in a police force he is working, still it will be he will try to communicate with his family members and his children, his wife, his mother, his parents, his father, everybody, all the relatives will be trying to. So there should always be remember that communicate. I'm sorry, there is no communication. No, there is no communication for the last 7 years. So here comes the section 108 exception, which is very important for us to understand. Now, once we know that person is not traceable, the first thing we should do as a client, when a lady came to me, she said that my husband, I have not met him for the last 6 years. Then I told you have to just complete the 7 years, but she was telling me I have not lodged the complaint. Now the here, when we go to the court counts 7 years period. So if she has not lodged the complaint for the 6 years, those 6 years will not be counted. The police gives certificate only after the 7 years completion. Always remember this. And in the court, you need to have a decree. You need to have a decree passed from the civil court that this person is not available or the person is not has not communicated and he would have otherwise would have contacted, and these are the people who has to get the declaration from the court. So civil decree from the civil courts and the police complaint, and otherwise to the authorities. Suppose he is working with the government department, there also you should make a note of the same by writing an application that this person is not available. Suppose there is a pension. Now, how the pension will start for his family? Unless or until the department knows that this person is missing. Of course, these authorities will be asking the decree from the civil courts, also the police complaint, and many other things which may be required in a way. Now, here we can see a few of the judgments which will actually throw light on this aspect where we will know actually what is to be done. And I'm very happy to share this judgment because these are the judgments which have actually laid down the law and clear the procedure for a common people as well as the lawyers also. So these three judgments which I'm going to cite today, try to read it. I will not be able to succinctly give the complete brief of the case, but still I will try to give little information about the same. The first we go to Guwahati High Court's judgment. This is the case of the 2006. I'll share the citation also. This is a Gogoi sir's judgment. This is Amrana Begum Majumdar versus State of Assam. Now, in this matter, what had happened? The husband was working with the police force and he was actually kidnapped by the Ulfa extremists. Now, this in the Guwahati, when this person was kidnapped by them, the wife lodged a missing complaint. Now, here when she lodged a missing complaint, for her it was a kidnap. Now, when she's saying it is kidnap, she has to bring it on record. However, she was asking for the salary of the last 7 years in her writ petition. Also, she was asking that the family pension may be started because in the last 7 years, there is no communication. He being a husband, he would have contacted her unless and until he is actually available. Now, what happened here? He was not contacting, and there was a news report also that he has been kidnapped by the Ulfa extremists. Now, when he is taken away by this group of Ulfa extremists, what happened that when she applied for the pension, the department was not ready to give the pension because they were saying that there is no proof that he is alive or not. How can we start the pension? At the same time, there was for last 7 years, she was also claiming his salary, being in a government servant. They were also not even ready to pay the salary. The matter came before the Guwahati High Court by way of writ petition. When this writ petition came, the court decided in her favor in her favor by way of the pension, that the pension has to be allowed because she has shown that last 7 years there is no contact from him. She was able to prove that. but court disallowed the salary for the last 7 years because the salary has to be paid only when he works. Since court was totally impartial, court has actually properly balanced both the sides here, and very legally it has said that when he has not worked for last 7 years, their salary will not be paid, and it is left to the wisdom of the department whether she should be given some help or compensation. But her family pension was started. So this was a very big judgment, and it has referred the all the other celebrated, or I would say milestone judgments of the other courts also, and also the Supreme Courts also, which is another judgment which we will be discussing. Also, this judgment has actually set out the lot of procedure that even if you say that 6 years and 364 days, you can't. You have to complete 7 years. That is 7 years, not even 6 years or few days or 364 days. It has to be 365 days. Now there was also LIC policies and family pension, and many things were decided. Now we go to the next judgment, that is of the Supreme Court, that is LIC versus Anuradha. This is another landmark judgment, and here we see the human approach of the court. Here this lady, though she went to the High Court has allowed it, and the LIC approached the Supreme Court. Now here I would like to tell you, all of you, in this matter, what happened, that this Anuradha's husband was actually not in her contact for a long time, and when she wanted to connect, she was also unable to connect, and she went to LIC and she was asking the compensation of the LIC policies to be given in her favor. Now, what happened? The LIC says that for 2 years only the premium was paid, and you have not continued to pay the premium of the LIC policy. Now, see, LIC is the biggest insurance company in our country. We all know that LIC has this set of rules also. Now, when they say there was set of rules, there was section. There was in clause 14 of the LIC, which was saying that if the person who has taken out the LIC policy and the family finds out that he is missing, and see, LIC's policy a person takes out mainly for the people who are left behind after his death. Now here, when the Anuradha husband has taken out the policy, there was a premium paid only for 2 years. After that, there was no premium paid, and the policy lapsed. Anuradha got a letter from LIC that your policy has been lapsed. Now, when a policy is lapsed, we all know that she will not be paid any premium compensation. She took the matter to the High Court. High Court, in fact, allowed in her favor, and it says that though she had there is a manual of the LIC, which under section 14 it says that to policy to continue in LIC, even if the person is not to be heard for alive for last 7 years, you have to, if you want to take the benefit, you have to continuously pay for the 7 years the premium, which she did not pay. Now High Court did allow in her favor, but LIC went to the Supreme Court. Now here very interesting thing happened. Mr. GL Sanghi, he was a senior counsel in this matter. What did he do? He told that because of some reason they will, because High Court has allowed, will be paying the money to Miss Anuradha, the widow of the person who has taken out these policies. But we want the Supreme Court to decide for once and all. See, there are so many states in India, these, and there may be, there are different high courts. So few high courts may have taken a different task that LIC policy should not, even if the premium is not continued, that person has to be, the dependents of the LIC policy holders has to be paid the compensation. So Mr. Sanghi, the senior advocate, he wanted the Supreme Court to decide. He very fairly contested and very fairly submitted before the Supreme Court that in spite of whatever Supreme Court outcome, we will pay the complete compensation to Miss Anuradha, the widow of the policy holder. But we want the Supreme Court to decide this question of law, that if the, because there's section 14 as per the LIC manual says that if a person is not heard for last 7 years and his dependent wants to claim the LIC money, then they have to continue the policy for the next 7 years. Now here High Court held against the LIC, so they went to Supreme Court. Now here Mr. Sanghi said, we will abide by what the High Court has said, but we want the Supreme Court to decide this question for once and all, whether our section 14 should continue or not. Now the Supreme Court very fairly has said that if the LIC policy has to be continued, then it has to be a LIC policy. The claimant wants the money, they should continue to pay the premium. See, the LIC stands on one thing: if you continue to pay the premium, then only you will get the benefits. Now here the policy has lapsed. Still the LIC paid, but the Supreme Court decided in favor of the LIC. And what happened? Though Anuradha got the money, it has let down the LIC versus Anuradha. This is 2004 judgment of the Supreme Court by Justice Lahoti. It has let down the law for the entire country, that whether a person is available or not, the dependent should continue the pay the premium of the LIC policy. So this judgment is a landmark judgment. And see, in every, we will hardly find a person who does not have the LIC policy. So this judgment has to be, every lawyer, in fact, every country citizen should know this judgment, that if a person is not available, because this question will come only when the person is not available, and LIC policy is obviously taken out for the dependents. Now, and if you do not pay the premium, this is going to happen. So this judgment is important from that aspect as well. I would like to read a para from this judgment, LIC versus Anuradha. This is the last para. Before parting, we would like to make an observation. Unfortunately, some of the regions or states in India are insurgency affected. Insurgency, there may be rebel, there may be revolt. Like in Guwahati High Court judgment, there was a Ulfa extremist. There may be terrorist group. In Jammu Kashmir, we find so many things. The life has become uncertain there. People live constantly under fear of death, mostly in the areas where insurgency is there. Uncertainty of life has been accepted as a normal course of living. The Life Insurance Corporation as a social welfare institution. See how nicely it has been written. More so when life insurance has been nationalized and services not available in private sector. Should think of devising a policy available in insurgency of afflicted regions. In Maharashtra, also we have some Naxalite regions, Chandrapur, it is near Nagpur, which would take care of the assured and his family members in such areas. When the assured suddenly disappears or ceases to be traceable, maybe the beneficiaries or nominees do not even know the deceased had an insurance policy. See, it has everything has been taken out here. There may not be aware if the insurance premiums have been paid or have remained or not paid, and what were the due dates and other obligations to be performed by the assured to keep the policy alive, insurance policy, with terms and conditions suited to the requirements of the people inhabiting the, just a minute, inhabiting that area, and need to be revised and propagated. Mostly the militancy affected areas. Now see, when we read this judgment, we see that policy, LIC policy, see, though the today's lecture is legal one, this is going to affect the large people. There are actually, if you see the missing complaints and the data on the net, you will always find that it is increasing day by day. And mostly in Naxalite areas, it is really actually difficult. Naxalite area or terrorist areas, which is like near to the Pakistan border. Now, in these areas, it is possible that people may be missing. Now, here, if they have not been heard for the last 7 years, these are the judgments which can be useful to them. But the judgment says that you have to continue to pay the LIC premium. Of course, the Supreme Court has suggested there are possibilities that the person may not know. The person dependent may not know that actually the husband or the mother or the son has taken out LIC policy. If he is an army officer, He may be having the LIC policy, the mother may not, parents may not be knowing it. So it is this judgment also gives us something to tell that if you have taken out the policy, this is out of context, but I would like to tell that your family should know that there is an LIC policy. There is a possibility that your family may not be knowing. So this judgment is actually, I would say, from the Justice Lahuti's angle, if we read it, it is actually very well written judgment, and it is putting a wisdom in a lot of people in of us that our family should know what is going on in our life, where are our investments, what are the mutual funds available, what are the shares you have taken out, what are the policies, and how many banks you have the account. It is always good that our family knows it. Now, of course, there are days of internet now, and SMS and mobile. That time mobile was not so famous, or so everybody was not having access to mobile. But now it is easier to find out if there is a message from LIC. But there is a possibility that the mobile cell phone which you were handling at the time of your death may not be available with your family. So it's better we have a will written, or at least on a piece of paper, all the bank statements, bank account numbers, LIC policies, mutual funds. These are all important things our family should know. So in a way, this judgment is putting a lot of wisdom in for ourselves as well as the common people of the country. Next, we go to another judgment that is from the Nagpur bench. It is Sushila Babulalji Sawal versus State of Maharashtra. Now, this is again a very interesting judgment of a very recent one, that is 2016. Now, in this judgment, what happened? This Sushila was unable to, and her children were unable to trace the husband. Now, they went to the civil courts and they said, declare my husband or our father as dead. Now, the civil courts said that they have taken two objections, that actually you have not put anything on record that he is alive or not, or you have made some attempts to put that he is it was under specific relief act. And the second objection was that there is no defendant in this civil suit. Now there was a public notice given, there was no objection. Now when the matter came to before the High Court Nagpur bench has very wisely written this judgment again. Here they said that there is no need of defendant because there is no objection. Though they have given the public notice in the newspaper, there was no objection from anybody that he is alive. Now they had a property, they had some other documents also which has to be transferred in the name of Sushila and sir. Now the High Court said that there is no need of having defendants necessarily, because there may be people who have no objection. It is only between the families, and there was no dispute between the families. The family was together, the sons and the Sushila Babulalji Parmar were together, mother and children were together. So there was no defendant. So High Court held in favor of the Sushila, and they actually, when the matter went to the High Court has suggested that collector could have made the party. See, what is the collector's job? Collector is the somebody who is socially responsible. He is the father or the guardian of that area. Now here they could have made the collector as a party, because here it is really difficult for a family to kiske against mein case file kiya jaye. In these kind of matters, you can make a collector as a party when you go to civil court. And the matter when came before the High Court, State of Maharashtra was actually made the party. So it was actually very easy before, but that the court suggested in this judgment that the collector could have made party. So this was actually one more good step towards section 108 and 107, where we can use this judgment and we can help our clients and litigants. So these were all in total. So section 107 and 108, always remember, it does not speak about the physical death, but the fictional death. In the eyes of law, you are dead, but and for that you have to prove through court that person is not available and he is no more in this world. But it will be only in the eyes of law. There will not be a physical death because he is unavailable, and these are due to circumstances. So Indian Evidence Act actually very exhaustively dealt with this matters where there can be a fictional death and the person's dead body is not available. So this was all about